The Texas justice system is messy, so let's break it down. You're listening to So You Got Arrested, the podcast that tells you what really happens after an arrest. Hosted by BRCK Criminal Defense attorneys, we talk to the people who've lived it, worked in it, and been shaped by it. Whether you're facing charges or just want to understand your rights, your options, and the smart moves that could change everything, we've got your back.
So, Scott, we're into September. September brings about some good things. It brings about Labor Day holiday, the start of the college football season. Unfortunately, my Longhorns didn't do too well this past Saturday.
They look okay.
Yeah, well, they'll turn around, and the start of the NFL season. But September 1st also brings a whole new set of laws.
Right.
And so we have been getting some questions to our email, and I thank everyone for sending us your questions. You can email us at justarrestedpodcast@gmail.com. And we got an email asking about the new THC laws that are in effect. So I know it was in the news that Texas was trying to ban these THC products. And there was an issue as to whether they were going to address it during the special session. It did not get addressed. So THC products, as they're sold in these stores, are technically still legal here in Texas, with the exception of one thing. And that one thing are
the vape pens.
The vape pens, yeah.
Which I don't understand how they did that. That kind of snuck up on us.
Right, absolutely. So it's funny the way that law works, because the vape pens that contain any amount of THC are now illegal, but it's a funny law because the way that law works is it is illegal to distribute or market the vape pens. It's not illegal to be in possession, which is a little odd, but this could have an effect on people who work at these vape shops, because if you're caught selling, distributing, marketing these products, it's a Class A misdemeanor, which could result in a year of confinement and up to a $4,000 fine. So if you find yourself in trouble for that, please give us a call at BRCK Criminal Defense at 210-874-5080. But Scott, today I wanted to talk about things that people do that make their cases worse. And so
we got our top 10 list of things not to do when you've been arrested, folks.
Absolutely.
Top 10.
Absolutely. And so the number one thing on my list, I'm a huge fan of Better Call Saul. And there's this moment in Better Call Saul where he's coming in to meet with a client by the name of Badger. And Badger's meeting with an undercover police officer, and he, is talking to his client, and he says, "Hey, I'm just here to see if you said anything stupid." And by anything stupid, I mean anything at all.
Yeah.
Exactly right. And so one of the things you can do to make your case worse is trying to talk your way out of it. I mean, what's your experience with that?
Yeah. So unless look, a lot of people who pick up criminal cases are DWIs. And minor offenses, family violence cases. And generally, when you're worked up about it, so if you're drunk, everybody who's drunk always thinks they're fine, right? They're and so they think they're going to talk to, when the officer hears how sober they sound,
right,
they're going to immediately realize they're not driving while drunk. But the problem is, of course, they do not sound sober at all. And who is the best judge of whether someone's intoxicated or not? Not the person who's been drinking.
So the person saying, "Oh, I've just had a couple," right, thinking they're going to talk their way out of it, that's not going to.
It doesn't work. And plus, so you and I sit there afterwards and we watch the body cam of these, and clearly that's not who they usually are. Because one of the things you have to prove in a DWI is loss of normal use of mental or physical faculties. And when they're talking, it's clear to everybody there that's not how they normally are. Okay, so it's all used as evidence against you, and that you're not making sense when you're saying stuff.
Right. Well, and you were a longtime prosecutor. Mm-hmm. Did you ever see a situation where somebody said, "Hey, I just had a couple," and the officer said, "A couple? Oh, that's good. You can go on your way."
Never. And by the way, they always say two. Every single person who's pulled over for DWI, it's always, nobody just says one, nobody says five, nobody says four. Yeah. It's always two or a couple.
Right.
And we joke about it.
Yeah.
We joke about it, like they're always going to say two.
The first one and the last one.
Yeah.
Those are the ones that they're going to mention.
We kind of admire the people on a DWI when prosecutors who actually say, "No, I had four."
Yeah.
But
I've had a dozen.
Yeah.
The second big thing that comes up that can make cases much more complicated is agreeing to allow that officer to search your phone, to search your car, to search your house. Keep in mind, you do not have to agree to these things. You have a right to privacy. You can tell the officer, no, you're not going to search my vehicle. You're not going to search my house. You're not going to search my phone. I mean, what are your thoughts on that?
And because it sounds self-explanatory, right? Don't agree to let people search stuff. Okay. But here's how they do it. They pull you over, that you're suspected of having drugs in the car. Say you left a place that they're monitoring because it's a known drug dealer in this apartment complex. Okay. And they say, do you mind if you search the car? And you say, no, I don't want you to search my car. Okay. And then they say, okay, well, we're going to bring the drug dogs. It may take us about 30 minutes. So are you sure you want to wait that long? And then everybody's like, well, I don't want to wait 30 minutes. Go ahead and search my vehicle. Let me just be clear. The case law says that if they make you wait for a long time while they're getting the drug dog, we're going to be able to get that stuff thrown out.
Right.
Okay. But go ahead. Tell what's your thoughts about all that?
Well, I mean, yeah, that's exactly right. And the thing that I've never understood is I've seen plenty of cases where people know they have contraband in the vehicle, but for whatever reason, despite that, they say, no, go ahead and search, or they're going to bank on the fact that they're going to say, well, I didn't know that was in there, which never works. I mean, so I don't understand why people do it. The other thing to keep in mind, and some of these smaller counties, if there's a deputy or whatever saying, I'm going to get the drug dog at 2 a.m., right, that's not going to happen. I mean, a lot of times they have one deputy on duty, doing
There's
patrol.
Generally only one or two deputies that handle the drug dogs, depending on what county you're in, and they're not always on duty. Now, they can be called at any time. They know they're on call 24/7, but it takes a long time.
Right.
And so what the courts have looked at is it reasonable the amount of time they make you wait? And what we kind of know is that if they're making you wait 30 minutes, most courts are going to consider that unreasonable.
And I've always told clients, like, look, I wouldn't want an officer just going through my phone. I mean, I have pictures of my kids on there. I have personal information, credit card information. Not to say they're going to do anything with it, but we have a lot of our private lives on our phones.
Embarrassing text you sent to your wife.
There you go. Whatever the case may be, right? So there's nothing wrong with saying, no, that's my private information. You cannot go through it. If you want to go through it, get a search warrant. Yeah. That raises another issue. The third thing that we see is people doing something stupid that gives an officer probable cause, either reasonable suspicion to pull you over or probable cause for a search.
Or causes you to be arrested for a crime. So it's interesting because you were just talking about people know if they have contraband in their car just a second ago. Well, we have a guy, the nicest guy. He's been on probation for a while and been doing well. And for whatever reason, driving, the police lit him up. But he had no active warrants. He had nothing in his car, but he fled.
Right.
And so he led the police on a chase. Then he bailed out of the car and ran too. So he's got 2 new charges, evading a vehicle and evading on foot. And guess what? When you're on probation and you pick up new charges, it's going to take a Herculean effort for us to continue him on probation.
Right.
And he knows that. And so I'm finally like, so you didn't have anything in your car. You didn't have any warrants. Why did you run?
Exactly.
He just panicked.
Yeah. I've seen cases where people, know they have contraband in their car, but they're driving around with a broken taillight. They're driving around with the license plate light not working. And, and my thought is you're making the officer's job easy and you're making it far more likely that you're going to end up being arrested and going to jail.
What's even worse than that, we get a lot of people who are driving with expired registration and no license.
Right.
Right. And so don't take drugs in your car if you don't have everything up to date. Right.
Or the situation where, somebody's doing something they shouldn't be doing. And right before they get pulled over, they've smoked out in their vehicle. So the officer pulls up and they roll down that window and it's like a Snoop Dogg video with the smoke coming out. And then they have contraband in there. And it's like, look, I'm happy to represent, everyone. And I'm happy for people to pay us to do this job. But, people do need to be a little bit smarter to try to keep themselves out of trouble.
And a little bit smarter gets to our next item. Sometimes let's not talk so much.
That's exactly right. Yeah. And so I know in this day and age, it's common to want to share everything with your friends or your social media followers. But I can't tell you the number of times where people, the evidence on their case is stuff that they've generated, either through a text to their friends bragging about what they're doing, or through social media posts, or even pictures posing with some kind of contraband, something that they shouldn't have.
Almost every case that we've had recently in the last year or so that involves something involving gun charges or shooting, there's pictures that the police have gotten off somebody's phone or off Instagram or off Snapchat that somebody saved of that person with guns.
Right.
Okay. That doesn't help us.
And it makes it tough on your attorney when they go into court and they're saying, hey, my client, is a good guy. My client, was not involved in this, whatever the case may be. And then the prosecutor opens up their file and there's a huge 8x10 snapshot, of the guy on Instagram posing with a gun or something like that.
And it's usually a couple guns and a blunt in their mouth all at the same time. And they're like bad guns, like assault rifle guns.
Right. Yeah. And it's hard to go from there to, my guy is normally a very good guy other than his social media presence. Yeah. Although I guess maybe you could go the route like 50 Cent did a while back when he posed with all the money when he owed, money in bankruptcy and said, well, this is all fake. This is part of my image. That's a little bit different. He's a celebrity. Yeah. I don't know that most of our clients are going to be able to make that argument.
I've seen people as a prosecutor try to make that argument that that's not really their gun. I'm like, okay, but we're not saying it's your gun. We're saying you're holding it, right, and you've threatened to shoot the school.
Yeah, exactly.
We get a bunch of those.
Exactly. Yeah. So, just be careful with that stuff that you're keeping on your phone. And that also goes back to the issue of you shouldn't be allowing people just to search your phone without a search warrant.
Right.
There's another issue that comes up, a fifth point that, can complicate your case. And that's a situation where you already have a case pending. Mm-hmm. And while that case is pending and you have your lawyer and your lawyer's fighting for you and you're attending court, you go out, you do something stupid. You pick up another case.
Right. Yeah. And so what we tell all our clients is, so we've had clients who intox assaults, ag robberies, things like that. And we're able to get the bond reduced and get them out. And then it takes a while before the DA. I have a guy with an intox assault that took 1.5 years before they indicted him. Mm-hmm. And I could have sat there and made a fuss and like, oh, go ahead and hurry up and indict this. And then that wouldn't have done me any good. But what happens now is I'm able to go to the judge and say, look how good this guy has been doing mm-hmm. for the 1.5 years while he's been on GPS, while he's had the ignition interlock. He's been doing everything. So the DA cannot come in here and say this guy is a danger and not going to do well on probation. It's undisputed of the 1.5 years where he's been on pretrial conditions. We know he's going to do well on probation. So right. The only thing they can argue is we want to punish this guy.
Right.
Okay.
Right.
The opposite is we get somebody out and say, help me out, help me to do a good job for you by not picking up new crimes. And then all of a sudden they're in trouble again.
Right. And it doesn't even have to be a major crime. There are some crimes like public intoxication, which ordinarily, not ordinarily, but it's a Class C misdemeanor, meaning the only thing that you're going to do is pay a fine on that, maybe spend the night in the drunk tank. But if you currently have a felony DWI pending and you pick up one of those public intoxication cases, it's just going to make your case that much worse.
And if we end up having to go to trial on it because the only thing they offer us is 15 years in prison, they're going to beat us over the head with that. Like he knew that he was looking at time mm-hmm. and he was out drinking afterwards.
Yeah. After this guy is already in trouble, after he's already out on bond, after the case is already pending, he continued to drink in a public place, got arrested for a new offense.
So he clearly doesn't care about the consequences of his actions.
Yeah, it makes it far more difficult to defend you, mm-hmm. And it makes it far more likely that a judge or a jury is going to take a look at that and say, hey, this is not a good person for probation because while they were out on pretrial conditions, they continued to do things they weren't supposed to do and continued to get arrested. How likely are they to follow probation conditions?
That's right. So you can make your attorney's job easy or you can make your attorney's job hard. It's up to you.
That's absolutely right.
Yeah.
And we have the rest of our 10 that we'll get to after this break. Again, this is So You Got Arrested from BRCK Criminal Defense.
The attorneys at BRCK Criminal Defense have helped over 5,000 clients move on with their lives. When an arrest or accusation turns your life upside down, we have the knowledge, experience, and integrity to get your life back on track. Traditional legal ethics, modern legal tactics, the best defense possible to get you through the criminal justice system. Search BRCK Criminal Defense to see our reviews and find out why so many of our clients have trusted us to fight for them. BRCK Criminal Defense, helping our clients move on with their lives.
And so we get back to our list of 10 things that you can do to make your case worse. Number 6, we hit on this a little bit, but it's kind of memorializing these dumb things that you've done. We talked about taking pictures. You know, the other thing that's pretty big, there are things like Snapchat and TikTok.
Right.
You know, so we have everybody who wants to be internet famous. And so a lot of times they're recording videos of themselves doing these stupid things that, you know, are just going to get them in trouble down the road.
Yeah, and I'm not known for knowing my social media stuff. I'm not on Instagram.
You're not a TikToker?
I'm not on any of that.
You're on YouTube.
I am on YouTube,
Yeah.
and I'm on Facebook.
Yeah, there you go.
The old people's social media. But but the thing is, so I know my daughter and the younger generation tells me, oh, well, Snapchat's not saved, and so that I believe that to be true. But what happens is, somebody takes a screenshot of the Snapchat and then they send it to other people. So don't assume that just because it's on Snapchat, people aren't going to be able to get it.
No. I've had Snapchat come up in cases that I've been on before. I've had clients who have been surprised that their Snapchat was still around. And it's absolutely right. Somebody else has recorded it, taken a screenshot, done whatever, and then, of course, shared it with everybody else.
Right.
And now it ends up in that prosecutor's file to be used against you.
Right. And it hurts.
Absolutely.
It's
absolutely.
Not good.
Well, because it makes it seem, it's hard to argue that, you know, if somebody did something that they're remorseful if they were bragging about it on social media.
There was that murder case that we weren't handling just a little while ago. He was a rap star. He rapped about the murder that happened, and he did another murder in another county. Right?
Absolutely. Yeah, that can be difficult to say, hey, my client's very remorseful about this, aside from the fact that he was bragging about it.
And wrote a song about it.
Yeah, to his friends on social media.
Yeah.
Number 7. This is a big one.
Oh, yeah.
So a lot of times we have circumstances where somebody is maybe about to get in trouble for something small. Let's take an example of they got a little marijuana on them, right? So they're getting pulled over by police. They've got a little marijuana on them. And to try to get away with it, they toss the bag of marijuana outside the car. Now, what's the charge when that happens?
So I'm not a fan. I used to reject those as a prosecutor, some of those tampering with evidence charges.
Right, which is a felony.
Right, it's a felony. So you've turned what's a misdemeanor that's not a big deal.
A misdemeanor that you would, worst case scenario, you get probation.
Yeah, and we're probably going to be able to get you pretrial diversion if you have no criminal history.
Right.
Okay? But now you've turned it into a felony. And then, of course, you get the ones where they're trying to swallow it, and then the officer is trying to like force their jaws open.
Right.
It turns into a Donnybrook. I know the generation doesn't use the term Donnybrook anymore.
Right.
But
I'm assuming Donnybrook was like a 1960s pop star.
Yes. But yeah, and so then they get you for tamper with evidence, which is a felony.
Right.
And so
and it's felony that carries range of punishment of 2 to 10 years in prison.
Right. And so it doesn't make sense. Not to mention, you know, when I was a kid, I had a friend of mine that was pulled over and ate. It was not just marijuana. He had like a bunch of pills that were illegal. He swallowed them all, had a heart attack, and died.
Right.
Okay.
Right.
So even if it's a felony, folks, most of those felony drug cases, you're still going to get probation on. It's not worth dying because you want to swallow the drugs because you don't want to have to go to court and deal with a felony probation.
Right. Absolutely. Yeah. And you know, and it's just a lot of people don't know this. And a lot of times I'm representing young people who have these little marijuana cases, and they didn't know that by tossing that baggie of marijuana, which keep in mind, when an officer's behind you, they're running dash cam, right? So they're recording everything that's happening in the vehicle that's in front of them. And so you clearly see the bag fly out the window, and then the officer will go pick it up. And then, you know, they end up being charged with that felony. And not every prosecutor is as reasonable as my partner here. A lot of them will indict that case. And now all of a sudden, you know, you're looking at 2 to 10 years in prison because you were trying to avoid that misdemeanor charge.
Yeah. Yeah, it just doesn't make sense. But this is what happens when you're in tense situations. Sometimes you make very, very bad decisions.
Yeah.
And so if you're not sure what to do, don't do anything.
That's right. And it even extends to things like your personal devices. I've had cases where people are under investigation and they want to start deleting things off their phone, or they want to start, deleting things from the iPad. I always tell them, don't touch anything, because a lot of times you end up, the case for the tampering with evidence ends up being much worse or a much more solid case. I've had plenty of cases where people beat the underlying offense, but what they didn't beat was the tampering with evidence because they were deleting stuff.
Right. Yeah. It's always difficult, and just use your common sense, but clearly a lot of people don't have common sense to utilize.
Right.
And so,
or they're nervous, they're scared, they're doing whatever they can.
Right. And so if you're not sure what to do, just don't do anything. And we'll get to the last thing in a little bit, what you need to do.
Yeah.
Okay.
Well, don't do anything. Let your lawyer take care of it.
Yes.
Right. I know number 8, this is a big one for my partner here, Mr. Simpson.
Yes, it is.
And
But this applies to everything in life. Don't be a jerk. Okay. It's not just about so if you're a jerk with a police officer, the prosecutor is going to look at that and they're going to want to back up the police officer who you've told all kinds of ugly things to. Like when I get it, and it's being a jerk when you say, well, I know the mayor, right? We've had,
unless you're the governor and you say, well, I think you need to let us go on our way. Which,
Governor Perry.
Yeah.
Yes, that was wonderful. So we've had prosecutors who sat there and tried to pull the I'm a prosecutor thing when they were pulled over.
Okay.
Yes, we have, and they get in trouble at work. And do you think the police officer would feel like, oh, you're a prosecutor, I'm going to let you go, or oh, good, I get to arrest a prosecutor?
Yeah, I'm the opposite. I do not want an officer to know I'm a criminal defense attorney during the stop.
Of course.
I've had officers ask me, what are you doing, or where are you coming from? And I'm coming from court. And, I try not to mention, hey, I'm a criminal defense attorney, because I do worry that they would get, a little excited about the fact that I'm about to pop this guy. So
you get to tell their buddies, I arrested a defense attorney today, and then everybody buys them around.
There you go. That guy that had you on the stand last month. Yeah, I just arrested him. So, absolutely. And, and it can make a difference.
Yes.
So I've had cases, I'm not saying this is every case, but I've had cases where during a DWI, if somebody, again, I'm not saying you have to agree to all the searches and agree to do all the tests, but if somebody was at least cordial and not screaming and yelling at the officer, where the officer may not show up at the ALR hearing, right, which affects whether or not you get to keep your driver's license. So those things can make a difference. And I was thinking about this, just the other day, because as I've gotten older and as I've handled some of these cases, I get pulled over by police because I like to drive a little fast going wherever I'm going. And I would say over the last 3 months, I've probably received 3 warnings from police officers.
Really?
Where they had the option, where I was going 15 miles over, and I'm just polite the entire time. And yes, I understand, and my apologies, whatever it is. And okay, they give me the warning and they let me go. Now, I know that part of that is because I'm a little older. When I was a young guy with long hair and a goatee, I always felt like officers would give me a bunch of crap. So sometimes they're just going to do that based on how you look. But it does make a difference. And it may make a difference in you getting a warning, you not getting your vehicle searched, if you are at least polite and you don't go out of your way to antagonize the officer.
I didn't know you sped this much. We got to stop calling you Grandpa Steve behind your back. Got to stop. I didn't realize you were Leadfoot.
Yeah, absolutely. I'm always at least 10 miles an hour over the speed limit.
Okay.
So now number 9, this goes to after the point where you've been arrested. Okay. So let's say that the officers arrested you, they've taken you to the jail. You're now in front of that magistrate, and the magistrate is setting your bail, but they're also doing your bond conditions.
Right. And so a couple episodes ago, we had somebody from the magistrate's office talk about that kind of thing. And we see all kinds of people afterwards who have no idea what the conditions of their bond are.
Right.
Okay.
And that's important.
Yeah, it's kind of important because, where it comes up a lot is we have people on the family violence cases where they're told no contact with the person who they were accused of assaulting, who happens to be their significant other.
Right.
Okay. And so they get all kinds of things that are like, I had a guy that just a couple months ago, he was under the impression that he could have contact after 30 days because there was an emergency protective order that was done. But the conditions of bond said no contact at all.
Right.
So just because the emergency protective order is done didn't nullify the bond condition to have no contact at all. So sure enough, he's pulled over 60 days later for speeding. The gal's in the car with him. He picks up a new case for violation conditions of bond.
Right. And those bond conditions, those remain in effect until the case is over. Those conditions are in place the entire time you're out on bond, which you're out on bond until the case is finally resolved.
Right. Which is, and we can get those conditions changed for you. We can't get them done like in a day. There's certain things. We have to file a motion. We have to get a hearing. Some judges will just agree to it. Some prosecutors will agree to changing the no contact to no harmful or injurious contact, which means you guys can be together. You just can't threaten or hurt each other anymore.
Right. And along those lines, one of the things that can be frustrating as a defense attorney is when somebody comes in to do a consultation with me and I ask them for their paperwork that they received when they got out of jail and they've lost it. That paperwork has very important information for you. I mean, it has your bond conditions. It may be that emergency protective order, which if you violate, you can be arrested for that.
Right. And we don't necessarily know how long the emergency protective order can be, from 30 to 90 days.
That's right.
The order itself has it on there, but it's not easy for us to get a copy of that emergency protective order. You have to go to the JP in smaller counties. It's not easy to get your hands on it.
Right.
Okay?
Right.
And so we don't, and so we kind of need to see that, because if you're telling me it's only good for 30 days, well, I want to see it.
Right.
Are you right?
Yeah. So whenever you're arrested, when you get out of jail, you should have paperwork, and you need to hold on to that paperwork and provide it to your attorney, because that's going to be very valuable in them determining how they're going to handle your case, what conditions you have in effect, what needs to be done immediately to help you either get back home, get back to your job, whatever the case may be, allow you to travel outside of the county or wherever you may be.
Which brings us to our next point, though. Get an attorney on board early. Okay. It doesn't have to be us. We're very good at what we do, but don't wait until, oh, geez, me and my wife want to go watch our son's recital together. Okay. Let me hire an attorney and it's Thursday and the recital's Friday.
Right.
Okay.
Right.
Get an attorney on board early so we can get on top of things early. Stuff that happens before we get involved, we can't turn back the clock and fix it half the time.
That's right. And I've had plenty of people that come in and they, maybe settle for an attorney that they don't want initially. And then right before court, or when they get a bad offer from the state or they're coming up for trial, they try to hire the attorney that they want. And I always tell people, it's like building a house. If I have a bad foundation, all I'm allowed to do is build on that bad foundation. I can't redo the entire thing because the case is already underway. So you need to get the lawyer that you want, the lawyer that you think is going to do the best job for you right at the outset. Don't wait too long.
Correct.
And that leads me to kind of a bonus tip that I would give, because this comes up a lot. There's a lot of people who assume that if the case does not go the way they want it, well, I'll just win it on appeal. I hear that all the time from people, like, well, can't we just win that on appeal? It doesn't necessarily work that way. Hardly
any cases are reversed on appeal. Before I went to law school, I thought appeal, they redid the trial all over again.
Sure.
Appeal is all the appellate court looks at is the record the court reporter took down of the plea or the trial or things like that, and they look to see if anything improper happened.
That's it.
And I don't know what the appellate reversal rate is, but I know it's very low. It's right. Probably under 5%.
Right.
So unless the judge, if the judge rules our way throughout the trial, we don't have an appealable issue. I mean, they're still going to appeal it, but you're not going to win anything.
That's right. Yeah. Right. So, I mean, people assume, like Scott said, that, well, an appeal is just a do-over. It's not a do-over. They're not successful that often. So try to get it right the first time. Try to get the right attorney at the outset who's going to do a good job for you and take care of your case the way it should be done at the outset. That's something that we'd certainly be happy to help with. You can always reach us at 210-874-5080. This has been So You Got Arrested with Scott Simpson and Steve Barrera.
A lot of trial experience between the two of us.
There you go.
Thanks for listening to So You Got Arrested. If you found this podcast helpful, share it with someone who needs to hear it. For more legal insights and real talk from the front lines of the Texas justice system, follow us and subscribe. And remember, BRCK Criminal Defense has your back. For more information, visit us at brckdefense.com.